Okay, wonderful. I first have to say thank you so much, Surabhi, for not only inviting me, but also just for setting up this series. It's such a wonderful thing, and it's so wonderful that you have this lecture series here at Sheffield. And I am so grateful to you for thinking of me as a speaker and for allowing me this time to talk about this new project I'm working on. Also, I want to express my thanks to Amnik for designing me a poster. No one has ever designed a poster about my work before. It is so exciting. So it's wonderful to be here, and thank you very much, and thank you to all of you for coming on a Friday. I want to use the time I have here, as Surabhi has said, to talk about intersex rights. Almost more specifically, I want to talk about the way in which intersex activists and groups have attempted to use human rights mechanisms to prevent gender normalizing surgery on intersex children and intersex infants. So my own engagement with this really quite challenging area of law, there we go. With this challenging area of human rights law, owes first a huge debt of gratitude to the brilliant Faye Garland and Mitch Travis, and to the intersex activists who have worked with Mitch and Faye over a long period of time. It feels kind of weird to start off a solo presentation plugging someone else's book, but I've put it there on the slide. It really is fantastic. They have done brilliant work in this area for a very long time. Mitch and Faye approached me a couple of years ago, and they asked me, they were looking for a human rights scholar to essentially write the human rights law around what they were doing, and around some work that they'd begun on intersex rights at the UN. So my background is both human rights law and LGBTQ plus rights, so I fit the bill pretty well. That work has just been published on the slide there, and that work is sort of a jumping off point for what I want to talk about today. So intersex. Very briefly, intersex refers to a variety of conditions in which a person has both male and female characteristics, either genetically or physically. The prevalence of those born with ambiguous genitalia isn't actually that rare. There's estimates of around 1 in every 2,000 babies undergoing medical investigation and a diagnosis of atypical chromosomal or gonadal sex. In many jurisdictions, this medical investigation generally results in gender normalizing surgery. That is surgery that assigns the baby to one sex or another, despite the fact that this surgery is not actually usually or often medically necessary. Surgery is instead quite often based on socio-cultural considerations, rather than upon medical need. It's often referred to as kind of a locker room test. Will this child be teased by their peers in a changing room? If so, we will intervene. So not only do these non-therapeutic interventions involve significant permanent interferences with the intersex infant's body, but they have long-term effects. During puberty, further surgery or medical intervention might be needed, and it can cause long-term harm, both physically, including sterilisation and vaginal stenosis, and psychosocially. So this is a big intervention at the beginning of an infant's life. And as I've said, a key aim of many intersex activists is to end these non-therapeutic interventions, at least until a child is old enough to be involved in the decision-making process about their own body and their own autonomy. Increasingly, intersex activists and individuals have turned to human rights bodies, to the UN, and as I'm going to talk about later, to the European Court of Human Rights. And they frame this demand for an end to non-therapeutic intervention in human rights terms. So they frame it as a form of inhuman treatment in international human rights law, or as a violation of Article 3 of the European Convention on Human Rights. What I want to do with this talk is to reflect a little on this, to reflect a little on the pitfalls, the paradoxes, and the potentialities of human rights law for intersex activists. Mainly because of time, I'm going to talk a lot about potentialities and not so much about everything else. But I do want to acknowledge right at the start that human rights are a pretty double-edged sword when it comes to issues of gender and sexuality work and to issues of sex. So I'm very happy to expand on that in the Q&A if that's something you'd like to talk about further. Okay, so my plan is I'm going to talk a little bit first about intersex in relation to wider LGBTQ movements, and I think that will help give a bit of insight about how this talk links to the wider lecture series and why I was so excited to come and be able to do this talk kind of first. I'm then going to talk briefly about intersex rights at the UN, but I'm going to do that in a way that introduces this idea of legal bubbles that I take from that I give to the title of the talk. And then I'm going to move to talk about the European Court of Human Rights. And then I'm going to finish by making a couple of wider points about how bodies become intelligible to law and whether this intelligibility or whether this push for intelligibility in law can be used to force a more radical reading of some of the rights protections that are already in place. Okay, so LGBTQ rights and intersex. So it's very common to see the I of intersex included under the LGBT umbrella or the LGBTQ umbrella, so LGBTQI plus rights, for example. And there's many examples of the interaction of intersex concerns with wider sexual orientation and gender identity and queer communities. So was Valentino Vecchietti, founder of Intersex Equality Rights UK, a designer of this intersex progress pride flag, which was put all along Regent Street in London very recently. As Valentino has said, just like everyone else, people born with variations in their sex characteristics intersect with lesbian, gay, bisexual and straight sexualities, as well as with trans, non-binary, binary and cisgender identities. And of course, our population also intersects with race, class and disability. So there is this kind of intersectional idea being put forward here. However, while Vecchietti stresses synergies, Garland and Travis have also explored the diverse opinions of intersex individuals and groups, and they've looked at the relationship between intersex, queerness and LGBT activism. And what they found is actually a very varied picture. Some of their respondents recognise overlapping concerns and parallel struggles of LGBT plus and intersex campaigns, but at the same time, their research also shows or exposes tensions in these parallel paths, ranging from concerns that funding might be diverted to LGBTI groups who aren't actually that well practiced at working for intersex people. There's concerns that resources might be directed towards identity-based non-discrimination campaigns, which doesn't really get to the key concern of intersex activists about preventing this non-therapeutic intervention on infants. So as Garland and Travis suggest, many LGBT plus groups and queer scholars working in the field of gender have used the concept rather than the experience of being intersex as a method of affirming their own views about the fluidity of gender. So I had this whole bit in here about celebrating difference and finding solidarity across difference in non-heteronormative movements, but for reasons of time I had to take it out. I could have just done a whole half hour on that, but I wanted to flag this and I wanted to take this concern seriously. And that's why I'm so glad I got to do this paper in this series, and this first paper in this series. Apart from the fact that it's what I'm working on at the minute, and I'm really interested to hear feedback, it felt like a good opportunity to centralise the situation and the arguments of a group that is included under this LGBTQI plus umbrella, but to speak to the specific concerns of that group. Not ignore, and I can't ignore larger arguments about binarized sex and gender, that sits, but I'm keeping that in the background for now. And I'm going to talk about rights and surgery. And first I'm going to talk about intersex rights at the UN. So intersex as a human rights issue dates back to the 90s. Dates back to the 90s in the US at least, and it's really exploded in international forums over the last few years. Among the groups who have approached the UN, there seems to be a hope that human rights might be used to pop the untouchable legal bubble that seems to protect medical decision-making from human rights scrutiny. Untouchable legal bubble is a phrase that I've taken directly from a case that I'll put up on the slide a bit later. But I think it recalls Mariana Valverde's conception of a jurisdictional black box. When Valverde talks about black boxes, she talks about the idea that who governs what is always already decided. We come to law with established norms of what can legally be scrutinised, where it can legally be scrutinised, and how it can legally be scrutinised. And really, that's the challenge faced by intersex activists, this question of who governs what. Because the decision of who governs what happens to newborn intersex bodies is already decided and depoliticized. This is the realm of medical practitioners and parents, not of human rights law. This is a kind of jurisdictional and a scalar clash of who gets to set the right course of action, and it's reflected in recent responses by states such as the UK to UN human rights committees. So this on the slide is the UK response to the Committee on the Rights of the Child, and they've made a recommendation that the UK ensure that no one is subjected to medical or surgical treatment during infancy and childhood, among other things. And you know, there's a whole sentence on the slide and it's a much longer kind of response, but really the first 4 words are all we need. NHS England are responsible. In human rights terms, the state is responsible for preventing inhuman treatment in the form of harmful practices. What we see here is a scalar and jurisdictional shift that encloses intersex surgeries in a legal bubble, and that prevents the acknowledgement of intersex concerns in human rights terms. The NHS, not the UK, is responsible. This is a medical decision, not a human rights one. This is a challenge for intersex activists, to say the least. There's a clear recognition of their concerns at numerous UN forums, but bodies such as the Committee on the Rights of the Child only have persuasive power to pressure states into changing their laws and behaviours. They can make their recommendations, but it sort of stops there. So really for intersex activists, and this is something that I explored with Mitch and Faye in the published paper, is that approaching the UN might lead to long-term normative shifts, but it's not necessarily going to lead to short-term legal change. Which leads to the question, could other human rights jurisdictions be useful here? Does or could the European Convention on Human Rights offer anything more, at least for intersex activists in Europe? For non-legal audiences, I know this is an interdisciplinary lecture, the European Convention on Human Rights is the primary European human rights treaty, came into effect in 1953, immediately following World War II. The European Court of Human Rights is the oldest regional human rights court, and unlike the persuasive power of UN bodies, European Court of Human Rights decisions are binding, and states generally do acquiesce to the judgments of the court. In the UK, the Human Rights Act gives further effect to the European Court, the European Convention on Human Rights in UK law. Okay, that's kind of constitutional law bit over. The most immediate problem with the European Convention on Human Rights context is perhaps that this issue just hasn't really got to the court in the way that it's reached the UN. it's certainly not kind of as embedded as it is in these UN Human Rights Committee decisions or recommendations. Thus far, there's been one application that has gone to the court, and this involved a case in which the adult intersex applicant argued that the treatment that they underwent as a child amounted to a violation of Article 3, which is the protection against torture, inhuman and degrading treatment in the Convention. The applicant in this case underwent 5 surgical interventions in the first 6 years of their life, intended to make their sex characteristics female. Now, this case was found to be inadmissible by the European Court of Human Rights, essentially on a technicality. There are a number of conditions that a case must meet for the Strasbourg court to hear it, and it was judged that these conditions had not been met. However, in finding the application manifestly unfounded, the court did make a number of interesting comments, and this has led some commentators to frame this as the recognition of intersex persons, but not yet their bodily integrity. Perhaps encouragingly, the court noted a medical procedure carried out without medical necessity and without informed consent is likely to constitute ill treatment under Article 3-ish. I mean, that's my translation of the French, but that sounds sort of court-type language. However, the court continued that an act that was deemed medically necessary according to established practices cannot in principle be regarded as inhuman or degrading, but that this medical necessity must be convincingly demonstrated. There is then perhaps a tentative possibility that the court is open to recognising the Article 3 implications of intersex surgery should the right case come along. If this did happen, it would be very welcome, both for intersex activists and for the wider case law of the court, because current precedent is not particularly encouraging. The leading judgment on Article 3 and medical treatment dates back to 1992, and it was not particularly popular even then. It's the case of Herzog-Valgi in Austria. And this concerned the forcible administration to a patient of food and neuroleptics, their isolation and their handcuffing to a bed in a psychiatric hospital. The applicant argued that this amounted to a violation of Article 3 of the Convention, but the court, on hearing this case, found no violation. It concluded that the established principles of medicine are admittedly in principle decisive in such cases. As a general rule, a measure which is a therapeutic necessity cannot be regarded as inhuman or degrading. The court must nevertheless satisfy itself that the medical necessity has been convincingly shown to exist. And I guess the worry here is that despite the court in M sort of making statements about medical treatment being carried out with informed consent, it did also say things which drew on this language from this 1992 case. Either way, in this Herzog-Valgi case, there's a lot of deference to the medical profession. And I think there's resonances in this 1992 decision with the UK's response to the Committee on the Rights of the Child at the UN. There's this failure to recognise, perhaps, that something can be both a medical decision and a situation that has severe human rights implications. Herzog-Valgi, as I've said, it's old and it's much criticised. And I looked it up again for this talk, and everything I found was sort of rethinking this case and, what would the court do if it considered this kind of case now? So there's a lot of literature on it. And there's no guarantee that the court would follow this precedent, given the developments of the past 30 years. It's not bound by stare decisis. There's a living instrument principle that means that a court can depart from its past judgments. However, more recent case law concerning Article 2 of the European Convention on Human Rights, which is the right to life, and medical negligence, also seems to reproduce this attitude. This is from a dissenting opinion, so a minority opinion, in Lopes de Sousa Fernandes in Portugal. And Judge Pinto de Albuquerque uses this phrase of untouchable legal bubbles that I'm so interested in. That evading the question of specific protection of the individual right of each patient and instead protecting health professionals in an untouchable legal bubble renders the convention protection illusory for patients. This is not to say that the Strasbourg or the UK courts will always defer to medical opinion and will maintain the legal bubble in all circumstances. But for me, with these European cases, it does leave a little bit of a question mark. It remains to be seen whether there's a possibility of a jurisdictional shift here. It remains to be seen whether we can have a sort of opening of Valverde's black box or a popping of the legal bubble in relation to intersex human rights. In M, as I've shown, the arguments were advanced through Article 3, that the state had failed to protect M from ill treatment. And the court considered Article 3 but declined to consider arguments from third-party interveners that also raised anti-discrimination aspects of M's situation through the lens of Article 14 of the ECHR. Rather than dwell further on Article 3 or Article 14, I want to use the last 10 minutes that I've got to do something slightly different. So this far I've been talking about how intersex people might fit themselves into forms that might make them recognisable in human rights terms. What I want to do now is draw a little bit on human rights law, a little bit on domestic English law, and a little bit on domestic family law, and a little bit on theories of legal temporality to ask why it is that intersex people must always change to fit in their encounter with law. Could we read the protections enshrined in the ECHR differently in a way that not only better reflects intersex experience, but also gives us a more nuanced conception of how harm occurs over time? And so to do this, I turn to quite a lot of the academic commentary on intersex and non-genital cutting of children generally, which has spent considerable time analysing the potential of Article 8 of the European Convention on Human Rights in this area. Now, Article 8 protects private life, family life, home and correspondence. Within this first bit, this respect for private life, there's a long line of case law that understands private life as the protection of physical and psychological integrity and of autonomy. It's also a qualified right, so unlike Article 3, interferences with Article 8 are permitted, but they must be prescribed by law directed towards a legitimate aim and necessary in a democratic society. Like Article 3, the case law here is perhaps ambiguous, but commentators have suggested that protections of physical and psychological integrity might offer a route for protection of intersex infants from gender normalizing surgery. In particular, Mary Donnelly and Ursula Kilkelly have read the 2004 case of Glass as acknowledging a right to physical and psychological integrity which is not dependent on the subject's decision-making capacity. The child, even the child who can't consent, begins to be recognised as a rights-holding subject. Mary Fox and Michael Thompson have also considered the protection of both physical and psychological integrity of children, arguing for the child's emergent subjectivity. They've argued for the child's right to an open future, grounded in rights to bodily integrity and self-determination. In so doing, they engage with a developing literature that considers the treatment of intersex children through the lens of time and temporality. That includes arguments for delay or deferral of decision-making processes on surgery until a child can be included in that process. What's present, I think, in all of this commentary is a sensitivity to the embodiment of the intersex individual as someone who exists, who develops, who changes over time, while also being a rights holder at each moment of that existence, someone who's stable and static at the same time. There's a rich feminist discourse of embodiment and legal embodiment at play here that I develop in the longer paper a bit more, but suffice to say that Ruth Fletcher and Emily Grabham and others have pointed to the over-surveillance and regulation of bodies that do not fit. And for me, this is ironic. The irony here in intersex issues is the weight carried by ambiguous genitalia. It's so striking, a tiny part of the body that drags with it a whole host of cultural, medical, normative and legal assertions. In short, the corporeality of the ambiguously sexed body, or indeed of any body that is sexed in any form, is epistemological and ontological. It's not just material. And by injecting a temporal focus into this materiality, it becomes possible to view how the initial act of surgery is not the only possible moment of harm. The applicant in M underwent numerous surgeries over several years, and intersex children will often face further interventions during puberty, as well as long-term health problems. Law's withdrawal and deference to medicine doesn't just occur in a single moment, but again and again and again over the life course into a future of continued consequences. There's a continual repetition of the past in the present, an ongoing retreat of law and repetition of the strict sex binary that caused the original harm. This expanded temporality is not easy to translate into the jurisprudence of the ECHR, but I think there's some interesting points to be made. In particular, along with bodily integrity, Article 8 protects the right to choose one's sexual identity, one's gender identity, and the right to make reproductive choices. As such, not only is there the repetition of the past into the present in the repeated interferences with Article 8, but the closing down of the possibility of rights that would come to be protected by Article 8 as the child aged. So non-therapeutic interventions on intersex infants represent both an immediate harm and also the jettisoning of a possibility of the full realisation of the scope of protections offered by Article 8 over an expanded temporal plane. Framing the intersex embodied person's experience in this way requires quite a complex approach to subjectivity. The stability of the rights-bearing subject and potentiality of the growing child must be held together in a way that is not necessarily particularly familiar in human rights law. Interestingly, the English courts have engaged, albeit briefly, with questions of temporality and shown some sympathy for the argument for delaying surgery in cases of circumcision. So in this case, a father applied to have his sons aged 6 and 4 circumcised, and that application was refused, in favour of deferring the decision to the point where each of the boys themselves will make their individual choice. L&B, this case doesn't really consider the contours of Article 8's relationship with physical and psychological integrity. It doesn't really consider the idea that different aspects of Article 8 rights protections might be brought together over an extended period. The focus is more on the children's best interests, and this is kind of an interesting conversation you can have with family lawyers, yeah. But it's interesting to consider how an argument might proceed. Such a claim would necessitate proper consideration of the second paragraph of Article 8, which requires a state, the UK before the European Court of Human Rights, or the NHS, public bodies before the UK court, to defend the idea of ongoing harm, ongoing interference with Article 8 through the lens of proportionality, and outside the stigmatising arguments of Article 3 that the courts seem very wary of. Authorities would be required to demonstrate that the harm that was caused was directed towards a legitimate aim, achieved the least possible harm, and was lawful. Article 8 encompasses the legitimate aim of the protection of health. And so with Article 3, I think these arguments would likely again turn upon the amount of deference that the court was willing to give to medical authorities. But I think this deference becomes increasingly difficult to sustain when you take an extended temporal view. From this expanded perspective, gender confirming surgery, or gender normalizing surgery, is not a single moment, but the first step in a process that has a ripple effect through the intersex person's life, encompassing the eventual intersex adult's capacity to make decisions about gender identity, sexuality, and reproductive autonomy, all issues upon which the court has expressed a clear and unambiguous view. So to finish, this is necessarily, I think, a radical reading of Article 8. I'm not expecting sort of these kind of arguments to go before the court anytime soon. And I think that the idea of asking a state to account for harm that persists across an extended period of a child's life, it goes far beyond current jurisprudence. I also think there's danger here. I can envisage situations where arguing potentialities could be dangerous. As Grabham reminds us, however, legal times are brewed. Time is not the background within which lawmaking happens, but an active and interactive part of the process. And thus the exclusion of an expanded temporality is a choice. Law's invisibilization here allows for the naturalization and axiomization of what follows. As such, intersex activists, their efforts are to bring the law back into focus, to force the re-emergence of the law in order to prevent the moment of harm or to provide redress for harm already suffered. And in this sense, it might be possible to use the procedural aspects of rights, particularly qualified rights, to force open the existing legal lacuna of intersex protections. More radically still, in so doing, this perspective invites us to take a much more careful approach to embodiment, to sex and gender, and to the possibility for accounting for slow violence and for ongoing harm. We'll finish that. Thank you very much.